Good morning. Thank you so much for joining us for today's Wednesday webinar, where we are going to cover Social Security disability for Crohn's disease. Before we go any further, I want to give my disclaimer that I give at the beginning of all of our webinars, which is that today's webinar is not meant to be legal advice, but is instead meant to serve as an additional resource and additional information if you or someone you know is looking at going through the Social Security disability process, specifically for Crohn's disease. If you are joining us on the live, you will hear me say, likely again at the end as well, that I do not answer questions on the live. And the reason for that is only because I typically need more information than I'm comfortable with you providing in a public forum. And so what I do ask is we will drop a link in the chat now on the live, and the link will be down below on the replay. If you do have questions, I want to help. I want to answer them. Please schedule a time to chat, or we'll provide the contact information at the end of the webinar as well. And you can feel free to reach out and give us a call or schedule a time. So that is why we don't answer questions on the live. I don't really respond to specific comments on the replay either, and that's for the same reason. I typically need more information than either what's provided, or if you go and post a long thing about a lot of identifying information, we usually don't approve those comments. And again, it's not because we don't want to help or don't want to answer, but it's because I don't want your personal information being out on the internet for forever. The internet's forever, as they say. So today we are going to talk about Social Security disability for Crohn's disease. And here's our roadmap for the day. We will first start talking about some Social Security disability basics like we often do, as well as some Social Security guidance. We will talk specifically about potential listing 5.06, which is where Crohn's disease tends to fall under. We'll talk about some additional considerations, and then we close out the webinar the same way we always do, which is some ways that an attorney may be able to help you with your disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability, PLLC, which is a law firm based in Florida where we exclusively practice federal administrative law, and we help clients with their Social Security disability cases from initial application all the way through the appeals council stage. So we are based in Florida. We can help outside of the state of Florida in certain circumstances. So please feel free, as I mentioned before, if you have questions, to reach out. If for some reason we cannot help, we do try to connect you with somebody who can. So there's no harm in at least reaching out just to see if it's something that we can help with. And again, if not, then we do try to put you in touch with somebody who can help you. Here's our Social Security disability basics. There are two different Social Security disability programs. There's Social Security Disability Insurance, or SSDI benefits, and there's Supplemental Security Income, or SSI benefits. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months due to one or more severe medically determinable impairments. They can be physical and or mental impairments, but you have to be disabled and unable to work for a period of at least a year. That does not mean that you have to be out of work for a year before applying. And in fact, I encourage people to apply as soon as you know that you're going to be disabled and unable to work for a year. If you've talked with your doctors and they say, look, we're here now, what are we, in May of 2023, it's unlikely that you'll be back at work before next July. Just based on your condition, whatever kind of treatment you have to go through, that's kind of what they're looking at. Go ahead and apply for disability benefits, even if today is the first day that you are not working. You worked yesterday, you worked full-time for 25 years, but today is your first day off work. Your doctor says, look, here's what we're looking at as far as a treatment plan. The soonest you're going to be back at work is likely going to be next July. Apply as soon as you can. Even if your doctor says that and they say next July is the earliest you'll be back at work, you say, great, I'll apply for disability. Let's say your treatment goes better than expected and you're back at work next January. You haven't met the duration requirement, no harm. Just withdraw your application for disability benefits, okay? So there's no harm in applying as soon as you know or think that you will be out of work for at least a year. Where the two programs differ is with SSDI benefits, those are benefits that are based on what you have paid into the system while you were able to work. So for SSDI benefits, therefore, you have to have a sufficient number of work credits. we typically say that you have to have worked for 5 of the last 10 years in order to qualify for SSDI benefits. For SSI benefits, on the other hand, those are income and asset restricted. So with SSI benefits, you do not have to have any type of work history, but you do have to be below the required income and asset thresholds. And right now, you cannot have more than $2,000 in assets if you are single and more than $3,000 in assets if you are married. As far as income, those are different thresholds, and I can't give as bright line and easy as an explanation because it depends on other factors, including earned versus unearned, as well as how many people live in the house and things like that. When you submit your application for disability benefits, this is the 5-step evaluation process. There's also a step 0, basically, for either of the programs, and that's making sure that you meet the additional prong. For SSDI, they're going to make sure that you have a sufficient number of work credits before they even evaluate your medical condition. For SSI benefits, they're going to want to make sure that you qualify from the financial perspective and that you don't have too much income or too many assets. Once you make it through that kind of step 0 hurdle, that's when this step starts, okay? They will first look, are you currently engaging in substantial gainful activity? Right now, that means, are you working more than 20 hours a week, or are you earning more than $1,470 a month in gross earnings? That's step 1. If you are working 20 hours a week or earning more than $1,470 a month in gross earnings, Social Security will deny your claim. They will say you cannot be found disabled according to our rules because you are engaging in substantial gainful activity, and therefore, by our definition, you cannot be disabled. If you are not working 20 hours a week or earning more than $1,470 a month, it'll go to step 2, where the agency will really begin to look at your medical records. And they are looking to see, do you have at least one severe medically determinable impairment? If you don't have at least one severe impairment that can be found in the medical records, again, they will deny the claim. If you have at least one severe impairment that's identifiable in the medical records, they go to step 3, where they look, okay, based on that severe impairment in all of your medical records, do you meet or equal one of the listings included in the Social Security Administration's Blue Book of Listings? The Blue Book, we will talk about one listing in just a moment. You'll see it's a very high threshold. Just because you don't meet or equal that listing does not mean you're not disabled. It just means that you don't meet or equal the listing. You'll get denied at step 3, and then they go to step 4. And what they do in between steps 3 and step 4 is they'll assign a residual functional capacity to you based on the medical records. And that residual functional capacity, or RFC, is what the agency believes you are capable of performing based on the medical records. By the way, if you do meet or equal listing, the evaluation stops there, you're approved. If you don't, that's where we go to the RFC. And using that RFC, the agency will look to see, okay, can an individual with that RFC perform your past relevant work? Past relevant work is any work that you've done in the last 15 years, long enough to learn how to do the job. If you can go back to your past relevant work based on the RFC, then Social Security will deny the case. They'll say you can go back and do your past relevant work. If you cannot go back to your past relevant work based on your RFC, then they go to step 5 and they take that RFC again and they compare it with your age, your education, and your work history, including any transferable skills that you may have obtained. And they will look to see, can you engage in any other job that exists in the national economy? If you're under age 50, they are looking at any job that exists. If you are over age 50, they do take into account your age. They look at your past work history. They look at your transferable skills, things like that. But under age 50, they're looking at any job that exists in the national economy. Over age 50, they're still looking at that, but with some additional parameters in place. As I've mentioned, the bar to meet the listing is pretty high. You can still qualify for SSDI benefits if your residual functional capacity, or the RFC that we were talking about, is less than what your past relevant work would require, and it prohibits you from engaging in substantial gainful activity on a regular and ongoing basis. This can mean that you are unable to sustain competitive employment. It can also mean that you may meet one of the grid rules if you are over age 50. Okay, the slide says you can still qualify for SSDI benefits. You can also still qualify for SSI benefits. It's the same as if your RFC is less than what your past work would require, and or that it prohibits you from engaging in any type of substantial gainful activity, including your past work, then you can still be found disabled. That's both under SSDI and SSI. Just a clarification. Okay, here we've got the listing that we're going to talk about today, specific to Crohn's disease, which is the 5.06 inflammatory bowel disease. So as you can see, it does have to be documented by an endoscopy, a biopsy, other type of appropriate medically acceptable imaging, or operative findings. So that is a must. If you do not have any type of one of those four, documenting your IBD or your Crohn's, and you're instead going off of just, this is what I feel like, it cannot meet the listing. In addition to that endoscopy, biopsy, medical imaging, or operative findings, you also will need to have either A or B. A is an obstruction of the stenotic areas in the small intestine or the colon with proximal dilation, again, confirmed by appropriate medically acceptable imaging or in surgery, and you have to have a hospitalization, okay? That has to occur at least twice, 2 months apart, within 6 months, okay? So as you can see, that is a very, very, very strict definition. The alternative is if you don't have that, but you do still have the endoscopy, biopsy, appropriate medically acceptable imaging, and operative findings, but you don't have 2 hospitalizations 2 months apart within 6 months, you can also look at 5.06B, which again is going to look at a 6-month period, and you have to be following prescribed treatment twice. That one of these has to happen twice. You've got to have anemia with hemoglobin of less than 10 grams per DL present on at least 2 evaluations, again, at least 60 days apart. You've got to have other blood work, the serum albumin of 3 per less. So you've got, you can see here that there's 2 possibilities on blood work. Okay, if you have your blood work done twice, at least 60 days apart, and you've got those figures coming back, that's one way to meet the listing. Also, if you have a clinically documented tender abdominal mass that they can feel on physical exam, as well as abdominal pain or cramping that's not controlled by prescribed narcotics. And again, it's got to be present at least twice, 60 days apart. Okay, so there's a few others, including, and this unfortunately happens with Crohn's frequently, where there's an involuntary weight loss of at least 10% from the baseline present on 2 evaluations 60 days apart. So it doesn't mean that, you lose 10% of your weight on May 1st and you qualify. No, it's got to be down on May 1st and then again on July 7th or something like that. Okay. Same with if you need a feeding line of any type. Okay, so those are the six additional ways that you can meet this listing. You have to have 2 of them happen within the same 6-month period. Additional considerations, as you can see from the listing, medical records are critical. The issue in Social Security disability cases is not just can you go back to your past work, but are there any jobs that exist in the national economy that you can perform? If you're 50 or older, the grid rules might apply, and functional capacity can also be relevant, particularly if you don't meet or equal one of the listings. Again, I put this twice on the slides. The first time I did it, it was an accident, but now I keep it because I want to hit home how objective medical records are so, so, so important. You can see in this instance, the listing itself specifically calls out that it needs the endoscopy, biopsy, medically acceptable imaging, or operative findings. That's objective medical evidence. So you have to have that. Same with the clinically documented abdominal mass that can be felt by examination. That's another kind of objective medical evidence. It's not just Miss Smith comes in and she tells me this is what's happening. No, but it's you can actually feel and tell that something is not right. Okay, finally, how can an attorney help you? As I typically mention, this is not everything that we can do. It's just some of the things that we can do. And it's some of the things that we kind of run into most often that people want to know if we can help with. And the first thing that we can do is we can provide information on what correspondence from Social Security actually means. Is it asking for a response? Is it just something to say, hey, FYI, keep this in your filing cabinet? What are they looking for? We can also file necessary appeals, either if you are already a client and receive a denial, or if you receive a denial and you let us know within a certain amount of time before the appeal is due. We can also help there. We do review your medical records in your case file, and we can also discuss what additional records might be helpful in your specific case. It's not always feasible to obtain additional records, including additional treatment from specialists, because resources are tight oftentimes when you're going through the disability process. But we do have that discussion with you, and if it is something that would help your case, and it is something that is feasible, fits in with your treatment plan, and is something that your doctors are also agreeing with and potentially even recommending, that can be helpful. We do not complete the questionnaires that Social Security sends to you, such as the supplemental pain questionnaire, supplemental anxiety questionnaire, supplemental cardiac questionnaire is another one, the adult function report. We don't fill those out on your behalf. Instead, what we can do is provide you some guidance about what Social Security is looking for in that. What's the purpose of them sending this form out? We always remind you to be honest, and then we can review, once the form is done, those forms for any kind of accuracy and completeness. If, for example, if you have always told us one thing and the medical records indicate, another thing, for example, that, you're bedbound most of the day, and all of a sudden in those forms, you're talking about the one time you went to a marathon last week. Well, no, you didn't run the marathon. You got up out of bed, got into the wheelchair, got into the car, went to the place where the marathon was being ran. You sat at the end, you cheered for your friend that was coming at the end, and then you went home. You were gone for a total of an hour that day. We'll ask you to clarify that. We, as I mentioned before, discuss what Social Security is looking for in those forms. You will hear me say time and time again, whether you're a client or whether you've watched multiple videos, always be honest. So we don't tell you, okay, Social Security needs to see this in this form. Because if that's not the reality for you, I don't want you to put that down. Social Security takes what you're putting in these forms and they compare it to the medical records, and they look to see how reliable of a witness you are, basically. So you want to make sure you're being honest and upfront. Don't sugarcoat and don't overstate what your limitations are. We do work with you to provide relevant updates to Social Security throughout your claim, and then we provide those updates back to you as we get them from Social Security as well. If you are at the hearing stage, we do prepare you for the hearing before the administrative law judge, and we will help you with what to do about witness statements. And then we do also sometimes question the additional witnesses that might be at the hearing, such as a medical witness or a vocational witness. As promised, here's our contact information. You can feel free to give us a call, send us an email. We will also drop the link in the chat again to schedule a call. The link to schedule a chat will also be down below on the replay. Thank you so much for joining us today. Have a wonderful day.